All right, so first exam covers chapters 1 through 3 and that digital estate planning stuff that we put together. You will have 2 short answers, and one of those is going to deal with that obituary that you wrote. So you are going to tell me about 2 of your classmates. When did they die, at what age, and what did they do with their life? You get the idea of building that network together. 15 multiple choice, 1 matching. So for that matching, you're going to want to know basically all the definitions at the back of each chapter. And you're going to line up the word with the definition, standard matching style. Calculation, we've done, covered that in class last week, where you had the married couple, and we'll see it in community property estate and in the separate property estate. What's the surviving spouse's basis in a home they purchased? So they're going to buy a home, it's going to be worth a certain amount, $200,000. One of them's going to pass away. At that time, the house is worth more, and we're going to see where that step 2 basis goes, depending on what kind of state they are in. So you'll do that calculation, and I'm kind of sneaking 2 of them in there because one will be for community, one will be for separate property estates. And these slides are in Blackboard. All right, so what is estate planning? We are getting all our stuff, we are figuring out what we want to do with it, and we are transferring wealth either while we're alive or in death, probably a combination of both. With that, for our clients and for ourselves, we're considering the legal, tax, and personal objectives, with the idea that we have a couple of ways that we can give property: effective and efficient. Effective, it goes to the person we want. Efficient, we're also maximizing what our loved ones receive. So that all those little things there, the idea is, if I wanted something to go to Susie, it's not all about the dollars and cents, that's going to Susie. With efficient, I'm also looking at how I can keep as much stuff in my loved one's hands as possible and as little to the government. Providing liquidity at death, we've talked about some ways to do that. You can set aside dollars, that idea of having an emergency fund of 3 to 6 months, or life insurance. Client healthcare decisions, and what they want done. We've got different documents that will cover that. So there's our effective and efficient. Those 2 words, what they are. Some of those back of the chapter definition words: who died, the decedent. Who's getting a gift, donee. Who's receiving a transfer, transferee. You notice there's he's and ors: the transferor, the grantor, the grantee. When we get into these things, the or is the one that's creating it or giving it. The e is the one that's receiving it. Principal, grantor, creates a power of attorney. We looked at our 2 different types: broadly, general, and limited or specific powers of attorney. The agent's the one that has that power. We have an executor and administrator doing the exact same things, but the executor is somebody that I appointed. If I appoint the executor, they don't have to post a surety bond, while the administrator is going to be appointed by the court. And this could, even if I named executors, the court might have to, if my executors have passed away, they're somehow unable because they're dead or incompetent or something, or unwilling to serve. In that case, the court steps in and they try to find somebody to do that. That person's going to get paid out of the estate. With the executor, there's the option of them getting paid or not, and they're the ones that get to choose that. You can't dictate from your will, executor gets nothing. Executor could choose. Example of that would be, I have siblings. If I'm appointed as court executor and my dad says I want to divide it up between the 4 of you equally, cool, we can do that, but I can get paid first. Or I can choose not to get paid and divide it into quarters between me and my siblings. Places, and this is more definitional stuff. Domicile is where I live. If I die intestate or partially intestate, wherever I'm domiciled, wherever I'm a resident, that state intestacy schemes will dictate how my stuff is given away. Situs is where the property is located. So if I have that cabin in Colorado, that's the situs of the cabin. If I'm a resident of Alabama, the cabin has to go through what's called ancillary probate in Colorado. So we would have multiple states, depending on where all my stuff is, where it's going to be more costly, it's going to take longer for my loved ones to get it, because it has to go through that process in every single state where the property is located. If we don't plan, the biggest thing is chaos. If you pass away without a plan, your loved ones might be fighting over what stuff you have, especially true if there's more to fight over. So wealthier estates that might be subject to taxation. Remember, our 13.9 million is the 2025 number. That tends to go up every year. Most estates aren't facing taxation, and we have our unlimited marital deduction, unlimited charitable deduction to reduce that further. With this idea of chaos, it's making sure that everybody knows where things are going. We've got clear words. We've disinherited somebody clearly saying, I give nothing to Max in the will, so that Max can say, oh, he forgot about me. We want to make it as hard as possible for them to try to not follow my wishes. While I'm alive, I want to have plans for being in a hospital for a long time. So I've got short-term and long-term care set up. I want my loved ones to not have to guess what my wishes would be should I fall into a coma. Now, we talked about Terri Schiavo. I want to leave that chaos behind. So I want all these things spelled out very clearly for my loved ones. This goes into that efficient and effective transfer. Effective to the specific person I wanted, efficient in a way that maximizes what they receive and minimizes what I pay to go. My client's family may not be provided for financially. I may not have a lot. Could be like a young family, got kids, we've got a mortgage, we've got life insurance. Term life insurance would be very cheap for them, and could make sure that the kids are able to go to college. Now, liquidity to cover stuff. Life insurance could be an answer there, and we can create what's called ILIT, Irrevocable Life Insurance Trust. We'll get into those more when we get into the trust chapter. So as an estate planner or a financial planner, you're going through the same kind of things. We want assets and liabilities. I want net worth, cash flows, seeing all these things. Same idea with estate planning. Here I want to know all their stuff. I would already have that as a financial planner. Family information. So I want to know if there is bad blood between ex-spouse and children. Are there any other things I need to be aware of when putting this together? Copies of all their policies. If they've got life insurance, I want to know how much. I want to know what the beneficiary designations are. And that's the biggest thing you can do as a financial planner. You'll see in your study guide, I've bolded that, underlined it, italicized it. That's the biggest thing you can do for your clients, is make sure that beneficiary designations are up to date. If they have any annuities, annuities, depending on how you set them up, could potentially pay benefits past your death. So it could go to a spouse, it could go to somebody else, depending on the annuity, depending on the contract. And that would be something that you would choose. You would help your client choose, if they were your client, what's going to be most advantageous. Is it better for them to get 100% during their life? Is there a term certain that it pays out? Maybe it has to pay out at least 50% of what is expected to pay out when you get hit by a bus. So money could be going to your estate. So I want that contract so I know if I'm going to be the executor, or if I'm just the financial planner and I'm sharing this with the executor, here's some dollars you need to make sure you get from this pension. Wills and trusts. The will is the document that lays out all the things that need to be retitled. When we get into the next chapter, the probate process is the process of retitling assets that don't automatically retitle themselves through that beneficiary designation, through titling. That's the operation of law. Trusts, the only way we can put strings on things, I could put in my will, this is for Ellie to be used for tuition. If it's in the will, they're not gonna validate the will, but they're gonna cross that line out to be used for tuition. You get whatever that asset is to use however you wish. If it's in a trust, I could say only if they maintain a certain GPA, only for up to a certain age, and it only pays these certain things. I can put all types of things in there to protect you from creditors suing you, and to protect you from yourself and suing you on something maybe I didn't want. So I've got more control over what it is done. Powers of attorney, general powers of attorney. Think of these for both financial and medical, and we'll look, these are separate documents, but you could give somebody the ability to make healthcare decisions for you. Make sure you trust that person. For those powers of attorney on the financial side, you don't want general power of attorney because then they can take out a loan in your name, they can sell your house, they can do anything that you can do with your stuff. If they die holding that power, all of your stuff is included in their estate. They can't give it away, but it could make their estate taxable. Limited power of attorney, we're doing something very specific. I want somebody to be able to pay my bills while I travel the world, or to sell my house, sign the closing documents, something like that, where I'm specifically limiting them to that scenario. Tax returns from before, all previous years, we probably don't want to go back real far, but at least the last few. Any gift tax returns, because those add up over time. We may not actually be paying taxes now, because we've got that 13.9 million, but those are going to, everything above the annual limit. If we get into gift taxes, it's $19,000 a year that I could give to every single person on the planet, and I'm not paying any taxes. I go 20,000, that's a $1,000 taxable gift, but I'm not necessarily paying taxes until I get over the 13.9. Assets transferred to loved ones, so this would be lifetime giving, because then we can help come up with a plan of, okay, you paid for daughter's wedding, help them out with the down payment with the house, maybe when you pass away, you want to be equitable and think, well, my two other children, I haven't given anything, so I want to give them more and not as much to daughter. And anything else you might need to know. How do they want to be buried? Have they purchased a funeral plot? All those little things. So we've got these common transfer objectives, effective and efficient again. You've seen that 3 times now, so you're probably going to see it on the exam. When we die, if we die with a will, you can appoint that court executor. They're going to be the one that handles all my stuff and make sure things get paid out where they're supposed to get paid out. Same exact thing for the court-appointed administrator. And with intestacy, we're going to follow, if you're a resident of Alabama, this intestacy scheme. For the most part, all the states have the same sort of setup. First to spouse, then to children. Here we've got a combination of the two, some to spouse and some to children, if we have children. Other states would just be 100% to spouse, and then figure the rest out. If we don't have a plan, depending on the state you're in, all the dollars could go to your spouse and your stepchildren, or children from a previous marriage are going to be treated like Cinderella. If you have a plan and you set it up, it's going where you want. Although recognize that spouse, if you cut them out entirely, can always contest the will and win, because they've got whatever the state says they should receive at minimum. Doesn't mean they're going to contest it. They always have the option to if you don't give them that bare minimum. Spouse may share assets with in-laws. Maybe you don't like the in-laws and didn't want them to receive anything, but spouse got it all, they can spend it all on themselves, and I'm not able to make sure that my biological child is still cared for. Spouse never liked him anyway, he was older, and they just never connected. Something that maybe I wouldn't have wanted to have done, but because it all went to spouse, because I didn't plan, the spouse is spending those dollars however she wants. Deceased children usually treated equally in intestacy. So let's say I don't have a spouse, it's Alabama, I've got 4 kids, or spouse dies with me or prior. Those 4 kids, I gave the example earlier of the daughter whose wedding I'd funded, helping out with the down payment of the house. All 4 of those kids are going to get the exact same amount under the intestacy laws of pretty much every state if we don't have a spouse. Other things we can do to let our wishes be known. The codicil, sort of 2 functions here. One, I'm changing some small thing from the will. The Mustang doesn't exist anymore, so I write a codicil saying, hey, the Mustang that was going to Sally doesn't exist, now I want the Camaro to go to Sally. Cool, now I didn't have to go spend as much getting a will drawn up. I can also use that as shields. So it's like armor for my will if I think there's going to be will contests. I can make as many codicils as I want, and they're cheap to make. Each codicil would have to be attacked one at a time. So if somebody wants to contest my will, saying, for whatever reason I was incompetent to make the will, I was under duress, I was fraudulently signing a document that I thought was something else, all of that would have to wait until they challenge each single codicil one at a time. So it's going to be a more expensive process for them. The idea being, well, if he was incompetent, he wouldn't have made this codicil. If he was competent to make this codicil, then everything before that he would have changed if he wasn't. Side instruction letter, that would be the how I want to be buried. Do I want an open casket? Do I want to be cremated? Do I want my body donated to science? Which some of that I could set up contractually before my death, so I could have already paid for the funeral home to pick this casket, all these things that would take some decisions away from my grieving family, so they don't have to worry about what casket to choose, where the funeral service is going to be, all that. I could have planned that ahead and had a contract for that. The side instruction letter is not a legally binding document. It's just, here's what I would like to have happen. Even if I set aside some dollars specifically to fund the all-you-can-eat shrimp buffet at my funeral, family doesn't have to spend it on that. It's not legally binding. If I kill someone and am convicted for it, I can't receive anything from their estate. So this doesn't count. I give the example in class. You've got a husband that got drunk, drives, and spouse is killed, he survives. That wouldn't be murder. It's, did you actually murder him? And are convicted. Divorce. So you might see a question where we have a couple in the process of going through a divorce. One gets hit by a bus, and the will gives all this money to spouse. The spouse gets to take that because we haven't actually divorced. We are still legally married, even though we are in the process. We've been separated for a year. We were filing the documents. The documents had already been submitted to the court, but until that divorce is finalized, they would be able to take whatever against my estate that I didn't want them to have. Same token, if I've remarried, so divorce finalized, I've remarried, my will says to Betty. Now Betty's my previous wife, so it says Betty gets this, Betty gets that, Betty gets all these things. Court is going to automatically assume that I want a current spouse in there. So they'll put current spouse Susie's name instead for all those instances where I said Betty got something. If I do want Betty to have something, I have to make it clear in the will that I recognize that Betty is my ex-spouse. So to my ex-spouse Betty, I leave whatever. Feel free to interrupt anytime. Unauthorized practice of law, you can't do estate planning. You can't draw up these documents for clients. You can do them for yourself. So your assignment where you wrote your own will, assuming you did it correctly and you got it signed, that is a legally binding, legally valid will. But for somebody else, we can't do it, not unless we're an attorney. Basic documents, talk about wills, side instruction letters, not legally binding, powers of attorney for property and healthcare. Living will and advanced medical directive we haven't really talked about yet. Here we are looking at what do I want to have happen if I am in a coma. Do I want it to be a certain amount of time? Do I want there to be some signs of life, brain activity, whatever things I want to put in there? I can get as specific or general as I want, but I want my wishes to be clear. The real life example we talked about in class was Terry Schiavo, the wife, the daughter who fell into a coma. Parents wanted her to wake up. She's going to do it. She's going to get through. And so for years and years, she was kept alive in a vegetative state. Her husband saying, no, we need to move on. It's been years. She's not waking up. There's no progress. There's no mental activity. We've got to pull the plug. Both coming from a place of love, but because she didn't have a living will, they had to battle it out over court. Chaos was left behind. Not fun for anyone. The do not resuscitate order is for somebody who does not want CPR performed on them. They'll have bracelets. You'll see these in nursing homes a lot because to perform a CPR correctly, you're probably going to break some ribs. If you're already ill, if you already are in pain, it's going to be a horrible experience to recover from that. And you might just, the rest of your life, have a broken rib. If young and healthy, cool, you're going to recover no problem. The do not resuscitate order, if you don't realize that they have that in place and you give somebody CPR, you're covered under the Good Samaritan law. So if you know CPR, you're in a position, please don't hesitate. So if we've prepared this correctly, we are able to appoint an executor. We've probably got co-executors. I would want my loved one who knows my family and who I mean when I say Jeff and where Jeff lives and Jeff's phone number. If I'm leaving something, my brother Jeff, if I'm leaving something to him versus the attorney or the court-appointed person that might have to search a little bit to find that stuff. So I probably want two, one a loved one and one a professional, so that I make sure that the professional is doing the things they need to do. They're making sure my home stays insured after I pass away before it's sold, because if it burns down, I don't want my sister to be liable for the cost of that home. So I want to make sure all the legal things are correctly done. Orderly transfer of assets, they're not automatically transferred. How else are they automatically transferred? What's the big one that's in bold, italics, underlined on your study guide? Yeah, so those will automatically go. If it conflicts with what the will says, beneficiary designation wins. The other way is titling, operation of law. Designation of guardian for minors or dependents. Somebody had an adult child that had some sort of issue but was a dependent and needed a guardian. With a guardianship clause in the will, I can direct where the dependent goes. I want to make sure that whoever is taking my child, I've already had that discussion, so my sister, I would talk to her, and hopefully she gives a thumbs up. But if something should happen, even if I've named sister as guardian, that doesn't legally bind sister to become a guardian. She may be in a position where she just got in a car accident, maybe we were driving somewhere together, she's in a car accident, she's paralyzed, she's not going to be able to take care of my kids. So she would be unable, not necessarily unwilling, but unable to be a guardian. If I don't have a contingent guardian, if I haven't set something else up, the court's going to do its best to try to keep the child in the family somehow, but if nobody's able to take care of my kid can go foster care. We saw that guardian ad litem, which was the court-appointed guardianship. Transfer of assets to charity. If you remember that Alabama intestacy scheme and every single state scheme, once they run out of relatives, once they run out of that circle of spouse, children, parents, cousins, uncles, grandparents, once they've run out of all those, they can't find anyone, they just keep the money. So the state would get your stuff. If I want stuff to go to charity, I need to put it in the will or give it to them during my life, or it could be a beneficiary designation instead of trust to do it too. The unlimited marital deduction, I could have $1 billion estate. If I give $1 billion to spouse, taxes aren't touching it because the government views us as a single taxable entity. Eventually they'll get their dollars, but she could spend it down while she's alive or give it to whatever charities. Disinheritance, if I don't write a will, intestacy scheme, here's spouse, here's children, here's whoever. If I don't want one of my children to receive anything, or a parent or whoever that the intestacy scheme might have gone to, I'm not going to be able to do that. Minimizing the estate tax burden by taking advantage of marital and charitable deduction. And I might not know that I'm going to win the lottery right before I die. So now I've got all these dollars. I can put something in there, just a line saying, if my estate is taxable, put this much toward whatever percent is needed towards charity. So I'm going to put an exact dollar amount, but instead of the government getting it, it could go to my favorite charity or charities. People can still contest the will. There's nothing stopping them just because I say don't contest it in the will, or if you contest it, you receive nothing. That discourages, but that's not going to stop somebody. As long as I've clearly stated, hey, I leave nothing to Max, I don't have to go into detail. I could go into detail. Remember, the will is a public document. Certain restrictions, the court's not going to invalidate the will, but like I said earlier, if I put $10,000 to Ellie to be used for tuition, Ellie doesn't have to use it for tuition, Ellie can use it for whatever she wants, it's just going to be crossed out. Those automatic transfers, the beneficiary designations, the titling, I can't give it away in my will because I already gave it away somewhere else. Even if I listed that asset in my will, if I later changed the titling or added the beneficiary designation, and the timing doesn't matter. So I could have had this beneficiary designation 10 years ago, never updated it. I wrote my will last year and I gave that asset to somebody else, or it's still going to go back to that beneficiary designation. Because I can change that in 5 minutes where it takes more time to create the will. Poorly drafted will could be invalid. More likely, wishes would be misunderstood. So for a will to be valid, when you did your will thing, there's just a few basic things you need for a legally valid will. Identification and declaration clause, probably the same sentence. I, Rich Stebbins, declare this to be my last will and testament. I have to know what stuff I have and who my heirs might be. A pretty good idea of my stuff. I don't have to know everything down to the penny, but I got to know what stuff I have. And I got to know this is what I'm doing, so that this is my last will and testament. More likely, wishes are not going to be clearly understood. Also poorly drafted, we saw with Elvis. He was having his executor make all kinds of decisions as far as what goes where, which leaves chaos behind, puts the executor in a position where they're going to have to probably deal with some disagreements and some arguments and maybe get sued because I wanted that guitar or that jewelry or that whatever. Easy to revoke. Usually that's just this is my last will and testament, hereby revoking all previous wills and codicils. With that said, you don't want to actually physically destroy the previous one, because if we come into something where my most current will isn't quite clear, they can actually go back to previous versions. Did I clarify exactly what was going to happen there? So they could potentially pull, at least from that section, to better understand my wishes. The court's going to do their best to do what I wanted done with my stuff. Different types of wills. Holographic, you handwrite it. Non-competitive is that dying declaration. It's valid in Texas, it's not valid in Alabama. So you're out hunting, you trip, fall and as you're dying, you tell your buddy, hey, I give everything to you. That would work in Texas, but it wouldn't work here. Statutory will is the one you want. That's the one where the attorney draws it up. We've got the ones where you created Rocket Lawyer or the e-form. Those are legally valid if you follow the things. Mutual or reciprocal, that's the sweetheart will, where I give everything to sweetheart, sweetheart gives everything to me. These ones, I can change later, so I can walk back to that attorney the next day and like, hey, I want to change it. I don't actually want to give Susie everything. The joint will, you don't want. You might think, oh, it's a little bit cheaper to do. So married couple, young married couple goes in, creates this joint will. 10 years later, 20 years later, maybe they're divorced, maybe one's passed away, but we're still bound by the terms of that will we created 20 years ago. Easy to have the capacity to make a will. I already mentioned the things I needed. I understand what I'm doing. I know who I am. I know what stuff I've got, and I know who my loved ones are. Basic clauses, introduction and declaration I already talked about. Bequest, here's this specific thing I'm giving to you. Here's the contingent person that would receive it. So maybe I've got layers in that. I want a residuary clause for all the things that I'm not specifically naming. So the clothes you're wearing, the food in your fridge, all these little things. As long as I've got this residuary clause, I'm not going through intestacy. So I won't have to follow that intestacy scheme of whatever state or part of the estate. Executor, guardianship, talk about attestation is just those signatures at the end, and then the self-proving is a notary, also saw those. So then if the will is ever contested, it has to go through any sort of issues. It was notarized, we don't have to track down those witnesses. Other clauses that are less common. Disclaimer clause you don't need. Everybody has the right to disclaim. Doesn't matter whether the will says it or not. You can say, no, I don't want that asset. I can't direct where it goes. I can ask, hey, where is it going to go if I disclaim it? And if it goes to Jeff, cool, that's where I wanted it to go. If it's going to Sally and I don't want it to go to Sally, I would have to take it and then give it to Jeff. Simultaneous death, we died at the same time, or it's impossible to determine which one of us died first. So we get into a wreck, and by the time the paramedics get there, me and spouse are both dead. Some states are going to assume one died before the other. You can put this in there to say, hey, if you can't tell, assume spouse died before me. And I would say that's best practice, because now I have more control over where the assets go. Survivorship, they have to survive me by a certain period of time. So if they die in the next week, they couldn't receive it. And that survivorship clause, if you put it in, you can put it in for everybody that might be receiving something, or just for spouse, or just for whoever. Contingent, beneficiary, legatee, whatever, who's receiving something. Always think the worst is going to happen. Same with that guardianship. I want some contingent guardians. No contest. If I don't give them $5,000 or something basic and say they get nothing if they do contest, they've got nothing to lose other than the cost of the attorney's fees. I can further discourage that and make it harder for them with all those codicils I put in and clear language in my wills. Will drafted. Lifetime gifting, if I think lots of people are going to be contesting my will, I can set up trusts now, giving away my stuff. I can set up trusts in a way that they pay me while I'm alive, and then when I pass away, it goes somewhere else. So making it even harder for somebody to attack my estate and take something from it that I didn't want them to take. Validation of the will by the courts before my death. So the wills you have now, you can submit them to the court, and the court would say, cool, this is a valid will, and now that's your will. You could write a new one later, but that one would be a valid will. Different ways we can give things away. You can put this in my will, like to my children per stirpies by representation. So you can see the visual here. A had 3 children, so a third to each child, but B passed away, so the third got split among their children. D passed away, the third got down to his child. Per capita, now we're counting heads. So same situation, B and D have passed away, but 1, 2, 3, 4 heads. Now you're getting 4 fourths. And then more complicated per capita each generation. There were 3 children, so a third, and then, so A had 3 children, and then his children, he's got 3 grandchildren, they split equally what was remaining. Powers of attorney. So we don't want the general power, we want the limited power. We can make these springing, and we can make these durable. Springing, nobody has that medical power of attorney until I'm somehow unable to make those decisions myself. I'm under anesthesia, I got hit by a bus, I'm unconscious. Then my mom can make medical decisions on my behalf. If I make it durable after I wake up, she's still able to make those decisions. If I don't make it durable, it just springs into power when I'm incompetent. It goes away as soon as I wake up, as soon as I'm off the anesthesia and I'm thinking clearly. Want to make sure it's somebody we trust because they can abuse the power. Take all my things. Healthcare. Mentioned that. Springing power. And I can always revoke it. Even if it's durable, mom can still make those medical decisions on my behalf until I revoke her power. Living will. There was what we want to have happen. We want the plug pulled right away if I'm in a coma. DNR's talked about physician's order. This is going to be between you and a physician for some very specific things you want to have happen or not. You want to make sure that your fiduciaries, that executor, the trustee for your trust are basically somebody you can trust, and also that they know what they're doing. So there's going to be some age, mental capacity, emotional capacity, education, and experience. There's this idea that as long as somebody's doing their best, it's fine. They're a reasonable adult, maybe they didn't get a CFP, maybe they didn't take these courses, so they wouldn't know how to manage things as well, but as long as they're trying their best, they're okay. That's why you want to think, I want co-executors, I want co-trustees. My loved one and some sort of expert that knows how these things should be done, how assets should be invested within a trust, what things I can and can't pay out of the trust. And you've got somebody that can be the bad guy to say no to your cousin's startup business that you think is a terrible idea, or your loved one that thinks it's a terrible idea. Transparency, so this is the idea of we're not going to leave behind chaos. So people knew what I was going to do before I passed away. I didn't promise things to multiple people. Even if I did, it's not going to change where it goes. Whatever documents I have are where the assets go, but I don't want them fighting over it. Different types of property. We had our realty. That was the land and the building on the land that can't be picked up and moved. Potential issue there with a mobile home. Maybe we filed paperwork to make it permanent. Maybe we've done something structurally to make it affixed to the land in some way. Intangible personal property, basically things I can pick up. So your backpack is tangible personal property. Your couch, all these things that you can pick up and move. Intangible, now we have things we can't really touch. So I own royalties, I have a patent, I have these different things that are bringing in dollars. We talked about how instead of owning it as an individual, some of that stuff would die with me. Now where does that income stream go to? I could set it up to go to an LLC, or I could create an LLC and have that own these things that generate revenue. Now the LLC can keep renewing those things. Wizard of Oz, Wicked's out now. They don't have to pay anything to the estate of Frank L. Baum because it is public domain now. If Frank L. Baum had created a corporation to own that, it could have gone on in perpetuity. Digital estate planning. We got some slides at the end where know your digital stuffs. Like all the documents that you have on your laptop, your social media, anything like that, what happens to that stuff, where are the passwords, who's going to receive power over it. Different ways we can own stuff. Fee simple absolute, sole ownership is what most things are owned as. That's your shirt, you can do whatever you want with it. You could give it away, you could sell it, you could donate it to Goodwill. It's yours to do whatever you want, and nobody can tell you what you can or can't do with it. Tenancy in common, sort of the same idea, except multiple people own this asset or portions of it. Doesn't have to be 50-50 or 25-25-25. 25, it's whatever portion I contributed. Could be sweat equity, could be dollars, could be a combination of both. We've got 2 or more people that own these assets. I can still do whatever I want with my portion. I don't have to get permission from anybody else. And whatever percent I had when I pass away, that has to go through probate. Joint tenancy with the right of survivorship, now I don't have to go through probate, it goes through that titling mechanism. So same idea here, 2 or more people are owning in it. Tenancy by the entirety, almost identical to joint tenancy with the right of survivorship, except now it's a spouse. So spouse is going to receive my 50%. With tenancy by the entirety, it's always 50%, and it doesn't matter what percent we contribute. Joint tenancy with the right of survivorship could vary depending on state. Some are going to make it equal, some are going to allow you to do different amounts. Community property, we have 9 community property states where spouses own everything equally, unless I've got separate property that came in through a gift or an inheritance specifically in my name, or property I owned prior to the marriage. And if we've got a prenuptial agreement, we can address the interest that grows on my investment account that I had prior to marriage. Life estate, for the rest of my life, I get to live in this house, and then it goes to whoever, children, grandchildren, Susie. Versus term interest, where it's for the next 10 years, I get to live in this house, and then it goes to somebody else. Danger with the term interest is I could be kicked out. Kids would be like, no, you gotta leave, we wanna live there now, or you gotta start paying rent, something. I don't have the right to stay. In Louisiana, that's called a usufruct, or a usufruct. Same idea there. Yeah. Legal versus equitable. See that with your mortgage. Bank owns the title to the home. You're the one living there. You've got the equitable use. You're enjoying it. You're paying it however you want. With the trust, there's going to be the trust itself that owns the asset, and then the beneficiaries of the trust would be actually receiving some sort of benefit from it. The trustee would be charging for the work they're doing, but the equitable ownership is in the beneficiaries. Types of different properties, and this will be where you see the math. I'm going to have a tenancy by the entirety or joint tenancy for right of survivorship, where we've got a married couple that owns a home, and we will see that step to fair market value at death. Notice that in a community property state, it's 100%. Versus a separate property state where I keep my original 50 and then spouse's 50 is what I would step to. So if I bought a $200,000 house, me and spouse bought this $200,000 house, our basis is $100,000 each. So automatically we're spouses deemed 50-50. Doesn't matter that I paid for it, all deemed 50-50. 3 years later, 10 years later, whatever, let's say it's worth $500,000. I pass away. My value, my 50% ownership, that's $250,000. But spouse keeps their own original 50% of that 100. So $350,000 would be their basis. Unless we're in a community property state where it's the full 100, and then their new basis, they jump all of it up to $500,000. So that's the math problem you'll see on the exam. Digital estate planning, all my digital stuffs, what's going to happen to it after I pass away, and knowing all this stuff is going to be a big one. You may not care about your Word documents and spreadsheets and homework that you've done in class. your loved ones probably don't need them. But what about your social media? Who takes over that? We've got some legacy features for some of it, so you could have set that up ahead of time. Other things like your subscription accounts need to be canceled. You want to make sure that's known. Like I've got a Hulu, I've got a Disney Plus, Netflix, whatever different things out there. Maybe I own some movies on Amazon digitally, or books and movies, whatever. Access to your Vanguard or Fidelity or whatever. You don't want the executor having to struggle to get there. If you have a financial planner, they probably already have that access anyway. Have you got power of attorney to use it? So figure out what you have and how you're accessing them. Figure out what you want to do with those things, or your client, and then you appoint a digital executor. That doesn't have to be the same person for every single account. Maybe you want your sister to be the digital executor for your social media. Maybe you want somebody else to access your financial stuff. You know? And then store this someplace safe. You could create it in your will, and this could just be a will referencing, hey, all my digital stuff will be passed according to the terms of this document, and that document can be stored somewhere else. Which is a good idea, especially if you're putting account numbers and passwords into this document. You don't want that to be in the publicly probated will. And I've seen that before where they listed the exact account number in a will. Hopefully by the time it made its way public, those have been distributed how they're ever supposed to be distributed. All right, the end. A few minutes left. If you have questions, it's a lot. Exam 2 will be even more. All right, if no questions, we'll try. See you for the exam. And I'll post this as soon as I get back to my office.